Bonsoir, je suis ravie de vous accueillir tous ici pour cette conférence du MIDS. Je suis plus particulièrement ravie encore d'accueillir Pierre Mayer qui vient nous parler ce soir d'un sujet de grande actualité en matière d'arbitrage commercial qui sont les décisions contradictoires. And since English is the language of the MIDS and also the language of international arbitration, I now switch to English. And it is my pleasure to introduce Professor Mayer, who obviously needs no introduction in this circle. Professor Mayer is a professor at Paris 1, Panthéon-Sorbonne. He's been for many years. He's presently a partner at the law firm of Deckard in Paris after having been for many years counsel at the Couder firm. He's known to many of us and dear to our hearts as a writer, for his writings in private international law, and I'm certainly one of his readers who turns time and time again to his writings, especially to his treatise on private international law that is now in its 9th edition. I would also refer you to his general course at the Hague Academy about la coordination des ordres juridiques en droit privé. He's also known to all of us for his activities in international arbitration, for his writings, his many writings on many topics, and looking at the list of the publications again, what struck me is the focus and the interest on the powers and duties of the arbitrator and the relationship between the arbitrator and the norm that he applies. And I will not refer to you to his many writings on this topic, but what always strikes me most when I go back to reading Pierre's publications is, and I must say I had prepared all of this in French, so now I say this in French. C'est la finesse de l'analyse qui est particulièrement remarquable, qui moi me frappe chaque fois que je rouvre un des écrits de Pierre Mayer. Professor Mayer is also active on the side of practice in international arbitration. As an arbitrator, we have all known him, and more recently, often also as a counsel. And an interesting twist in his career path, I see him appear in major arbitrations as a counsel. We're extremely happy to have you here tonight, Pierre, and we look forward to your lecture on conflicting decisions in international commercial arbitration. You have the floor, either sitting or up here, whatever is most convenient.
Thank you, Gabrielle, for these two kind words. As you mentioned, my original field of interest in law was private international law, and only later did I develop an interest in arbitration. And as a specialist of private international law, I'm naturally very sensitive to the problem of conflicting decisions, because one of the main objectives of private international law, the main objective, according to Friedrich Karl von Savigny, is international harmony of solutions, which means that a given private law situation having connection with two or more states must be assessed in the same manner in all those states. Two conflicting judgments, one holding, for instance, that a marriage is valid, and another one holding that it's void, that is the very opposite to international harmony of solutions. There are specific procedural tools in private international law to prevent the appearance of those conflicts. First tool, the res judicata effect of a judgment previously rendered in a foreign country. In the both effects of res judicata, the negative effect that will prevent the introduction of the same claims before a second court, and the positive effect, which will oblige the second court to take as the expression of truth what has already been decided by the first judgment. Second tool, the stay of proceedings by the court when a foreign court has already been seized but has not yet rendered its judgment. It's a stay which can be based in civil law parlance on an exception de litispendance or an exception de connexité. The English and the Americans say generally forum non-convenience. But the distinction is interesting because it depends whether the new claim is identical to the first one, then it's exception de litispendance, or only closely related to it, and then it's exception de connexité. Now, can a parallel be drawn in that regard between private international law and arbitration law? To some extent, the answer is positive. In place of a problem of conflicting judgments, we will have a problem of conflicting awards. And that conflict may be avoided to some extent by using the same instruments. An arbitral tribunal can recognize the res judicata effect of an award previously rendered. An arbitral tribunal can stay the proceedings because another arbitral tribunal has been seized of the same dispute. On the other hand, there is no room for exception de connexité, which already is a difference. But what makes things more complex is that apart from the parallel that one can draw between conflicting judgments and conflicting awards, there is also to consider the combinations between judgments and awards. Since international commercial arbitration is intimately connected with the legal orders of states, state courts will allow the arbitration to take place or refuse it. They will recognize an award or refuse it, or enforce an award or refuse it, or consider and decide that it is valid or that it is void. So conflicts may involve not only awards, 2 awards or several awards, but also awards and state judgments. The combinations may be of 2 kinds. An award and a judgment may be conflicting. Or there may be a conflict between 2 judgments which concern international arbitration. For instance, one judgment on the recognition of an award and another judgment on the validity of the award. All these conflicts have to be considered. But there is a preliminary question. When can it be said that 2 decisions, either awards or judgments, or 1 award and 1 judgment, are in conflict? What is the nature of a conflict? I think a distinction has to be made between 3 kinds of conflicts. First, there is what could be called an absolute conflict, consisting in the fact that the decisions cannot be both enforced, physically cannot be both enforced. The enforcement of one makes it impossible to enforce the other one. For instance, an award orders the respondent to adopt a certain behavior, and another award enjoins the same respondent from adopting the same behavior. But such absolute conflicts are very rare, essentially because there can be no absolute conflict between 2 monetary decisions, and most disputes in the field of arbitration are monetary disputes. For instance, if an award orders to the respondent to pay $500 as damages to the claimant, and another award orders the same respondent to pay $1,000 for the same cause to the same claimant, it is not impossible to enforce both. It could even be said that by enforcing the award for the higher amount, one at the same time enforces the award for the lower amount. But in this example, we see that still there is a conflict of a second kind, in that the operative parts of the awards, the orders in the strict sense, or dispositif, are incompatible, materially incompatible, in the sense that to enforce one is necessarily to ignore the other one, to deprive it of its object. For instance, to enforce the award ordering to pay $1,000, one renders the award that ordered to pay only $500, limited the damages to $500, it renders that award meaningless. I will call that kind of conflict a material conflict, as opposed to a third kind of conflict, a purely intellectual conflict, consisting in the presence in the decisions, either in the reasons or in the dispositive part, of two logically incompatible statements. For instance, one decision adopts a certain interpretation of a clause in a contract, and another award adopts a different interpretation of the same contract or even an identical contract. Of course, where there is a material conflict, there is necessarily also behind an intellectual conflict. But the reverse is not true. There can be awards, or more broadly decisions, intellectually conflicting without there being a material conflict. Apart from this tripartite distinction in relation with the nature of the conflict, another distinction must be made concerning the dimension of the conflict. The conflict may exist within the legal order of one state. That would be the case, for instance, if in Switzerland there were two awards, both considered valid, but adopting logically incompatible views. But the conflict sometimes exists only because two different state legal orders have different views. One's considering that a certain award is binding, while another state legal order considers that it's another award which is intellectually or materially conflicting, that is binding. I would call the first type of conflict, internal to a legal order, and the second one an international conflict. International commercial arbitration can give rise to both internal and international conflicts. But since internal conflicts arise in the same manner in domestic arbitration, and the conference is about international commercial arbitration, I will focus, maybe not exclusively, but much more, on international conflicts which are specific to international commercial arbitration. Unfortunately, once two internationally conflicting decisions have been rendered, it is generally impossible to resolve the conflict. The two conflicting decisions will remain each in its legal order. And therefore, the only objective that legislation or case law may pursue is to limit the risk that a conflict appears. And therefore, the question that I will ask myself, the dual question that I will ask myself in this conference is, what are the causes for the risk of conflicting decisions, and to what extent can such risks be eliminated or at least limited? And for this, I will distinguish three kinds of conflicts: conflicts between two state judgments concerning one award, conflicts between one judgment and one award, and conflicts between two awards. Conflicts between two state judgments concerning one award. It is by nature an international conflict. For instance, a certain award is recognized in a certain country, but refused recognition in another country. It is not a material conflict. Both decisions can be given full effect, because the effect of each is limited to its own territorial sphere. But intellectually, of course, these awards, these decisions, judgments, are conflicting. The New York Convention of 1958 tends to prevent the conflicts to some extent by limiting the grounds for refusing recognition and by harmonizing the grounds between the numerous states that are parties to the Convention. But the harmonization is not complete. The Convention lists the grounds that may be opposed to recognition and enforcement, but it does not oblige the states to accept all these grounds. The legislation of one state may be more liberal than the New York Convention. And in addition, two courts may arrive at different conclusions, even when they apply the same provision. Even when the courts make serious efforts to take into account the position of the other state, for instance, because the law, the applicable law, is the law of the other state, and the second court accepts to apply that law. Even in that case, conflicts are not always avoided, and I will present a recent, or rather recent, example, but striking one, the decisions rendered by French courts and English courts in the Dalla case. In that case, the government of Pakistan wanted to conclude a contract with Dalla, which was a Saudi contractor, for the building of accommodations suitable for pilgrims traveling from Pakistan to Mecca. There were long negotiations. In the end, the government of Pakistan decided that it would not sign the contract itself, but it created a trust, the Awami Hajj Trust, and the trust signed the contract with Dalla. Only a few months after the execution of the contract, the Secretary of the Ministry of Religious Affairs of Pakistan, on its own letterhead, put an end to the contract, alleging that there had been fundamental breaches by Dalla. In fact, 1 month before, the trust had ceased to exist because it had been created by a decree which was valid for only 6 months, and that decree had not been renewed. So Dalla, who wasn't happy, couldn't sue the trust, which it did not exist, and then it had no other choice than to sue the government. There was an ICC Paris arbitration clause. Before the arbitral tribunal, the government challenged the jurisdiction of that tribunal because it was not a party to the contract. It never accepted the arbitration clause. Nevertheless, the arbitral tribunal assumed jurisdiction, noting that the government had been involved in the negotiation and the performance of the contract, which is a phrase directly taken from French case law, which is very liberal and accepts that even non-signatories can be considered parties to the arbitration clause when they have been involved in the negotiation and or the performance and or the termination of the contract. And on the merits, the arbitral tribunal found that the government owed £20 million to Dalla in damages. The government made an appeal before the Paris Court of Appeal. In parallel, Dalla seized the English courts and requested leave to enforce the award. Let's start with the English court. At every level, of the judicature. They reasoned in the same way: High Court, Court of Appeal, and Supreme Court. They found, first, that they had to apply French law as the law of the seat. And they understood that under French law, the involvement in the negotiation and or performance can make a non-signatory party to the arbitration clause, but they understood it in the following way, that such involvement had to reveal the intention of the non-signatory to become a party to the contract, not only to the arbitration clause, but to the contract. And they concluded that in spite of the involvement, the government did not have any intention to become a party to the contract. In the words of Lord Justice Moore-Bick, in typical common sense reasoning, English, if it had been the party's common intention, the government would surely have been named as a party, or would at least have added its signature. The Supreme Court confirmed the position of the Court of Appeal on the 3rd of November 2010. So the award is not enforceable in England. A few months later, the Paris Court of Appeal dismissed the appeal which had been made against the award. It considered that the arbitral tribunal had jurisdiction because the government had been involved in the negotiation and the performance and had even terminated the contract. So this case shows that although the English courts honestly tried to follow the French approach, it is so alien to British minds, and maybe not only to British minds, that they simply could not succeed, or at least did not succeed. So we now have two conflicting decisions, one in England and one in France. That is not the consequence of a difference in the applicable rules, but that of the irreconcilable difference in the legal culture of the judges. In that case, the court of the seat held that the award was valid, while the other court refused to recognize the award. The opposite situation also exists, although it is most often avoided. The court of the seat annuls the award, but it's still recognized in another country. But I will deal with that situation later because it causes other problems and adds a conflict of awards to the conflict of decisions. So that will be in the third part. But I now come to the second part. Conflicts between a judgment and an award. I will distinguish between a purely intellectual conflict and a material conflict. A purely intellectual conflict may easily occur each time there are closely related claims, but only some of them fall within the scope of the arbitration agreement. The same issue relevant to several claims may be decided differently by two arbitral tribunals, or rather by one arbitral tribunal having jurisdiction over certain claims and a state court having jurisdiction over other claims, but in both procedures the same factual or legal issues have to be decided. I won't insist on that situation because it is not specific to international arbitration. What about a material conflict between a judgment and an award deciding the merits of the same case? That may occur in the following circumstances, and that will be an international conflict, material international conflict. An arbitral tribunal, having its seat in country A, considers that it has jurisdiction over the dispute and renders an award. Although one of the parties in parallel has seized a court of country B, and that court considers that it has jurisdiction and renders a judgment which happens to be incompatible with the award. That's a material conflict. Are there ways to prevent such a conflict? Various solutions have been invented. I will mention three. The first one is very well known by each of you, but still I am obliged to mention it, even if I hope I will not say anything which is not accurate. The first solution is the solution that the Swiss Federal Court adopted in the famous Fomento decision in 2001. Fomento, a Spanish party, seized a court in Panama against the other party, Colon Container, a Panamanian party. The defendant objected that there was an arbitration clause in the contract, but the courts at various levels considered that this exception of lack of jurisdiction had not been raised in due time. Colon Container then filed a request for arbitration in Switzerland because the seat, according to the contract, was in Switzerland. The arbitral tribunal considered that it had jurisdiction. There was a valid arbitration clause. It refused to stay the proceedings in spite of the exception de litispendance raised by Fomento. The Tribunal Fédéral annulled the award. It considered that the arbitral tribunal should have stayed the proceedings because there was a situation of international lispendence. Article 9 of the Federal Act on Private International Law obliges a Swiss court to stay the proceedings when a foreign court has already been seized of the same claims between the same parties. And the provision does not apply per se to an arbitral tribunal even sitting in Switzerland, but the Tribunal Fédéral considers that the objective of the rules is precisely to avoid conflicting decisions, which is an objective that has a public policy character, and therefore the rule should also apply to an arbitral tribunal. That decision has been generally, although not unanimously, criticized. I venture with caution, because I'm not a Swiss lawyer, the following view. It seems to me that what was wrong with the Fomento decision, if something was wrong, was that it did not take into account the specific nature of the issue pending before the tribunal and the foreign courts, namely the applicability of the arbitration clause. If one does take it into consideration, it appears, first, that seen by the arbitral tribunal, the point of view that will be controlling is not that of the foreign court, but that of the Tribunal Fédéral, which has jurisdiction to decide whether the award is valid or not, which includes whether the arbitral tribunal had jurisdiction or not. And second, in turn, why should the Tribunal Fédéral, when exercising its control over the award, defer to the view of the foreign court? From the perspective of the court of the seat, whether the arbitral tribunal has jurisdiction depends exclusively on its own views. Therefore, the position of the Panamanian court is simply irrelevant. And why stay the proceedings? Because of the decision of a court whose position is not relevant. Now, the criticism was heard by the Swiss legislature. As you know, in 2007, it introduced a new paragraph in Article 186 of the Federal Act. The arbitral tribunal is allowed to rule on its jurisdiction regardless of whether the same cause is already pending before a court or an arbitral tribunal. And that, of course, creates the risk that the Tribunal Fédéral wanted to avoid. There may be a conflict between the foreign judgment and the award. The second means to prevent a conflict is used by the English courts. It's the anti-suit injunction. When the seat of arbitration agreed upon by the parties is in England, and nevertheless a party seizes a foreign court, an English court may enjoin that party from pursuing its action before the foreign court under the penalties of contempt of course, which is very dissuasive. Compared with fomento, this is in a way the exactly opposite means to solve the same problem. Priority is given, even somewhat brutally, to the arbitral tribunal and not to the foreign court. And there will be no conflict because there will be no foreign judgment if the claimant abides by the injunction. That works when the foreign court belongs to a state that is not a member of the European Union. And maybe one should add, which is not a state party to the Lugano Convention. But can an anti-suit injunction be addressed to a party that has seized the court of a country which is a member state of the European Union or which is a party to the Lugano Convention? In a case, a famous case called West Tankers, the House of Lords hesitated and preferred to ask the question to the Court of Justice of the European Union. The contract in dispute contained a clause providing for arbitration in London, but the claimants, two insurance companies, sued West Tankers before the Tribunal of Syracuse, Syracuse being the place of the damage. Italian courts sometimes take a long time before declining their jurisdiction. So the anti-suit injunction might have been helpful. The right answer was not easy to find. On the one hand, the Brussels I regulation on jurisdiction and the recognition of judgments within the European Union excludes arbitration from its scope of application. That's Article 1, Paragraph 2d. And therefore, it could be argued that the Brussels Convention regulation not being applicable cannot constitute a bar to an English court protecting an arbitration the way it pleases it. On the other hand, the Italian court had been validly seized and had, pursuant to the regulation, the power to decide itself on its jurisdiction, which would include the power to decide whether the arbitration clause constituted a bar to its jurisdiction. The Court of Justice, which is generally hostile to anti-suit injunctions, decided that in these circumstances the anti-suit injunction was not acceptable. It's a judgment of the 10th of February 2009. And the consequence is that there is a risk of conflict. An additional issue is the following. If the court of the seat is confronted with the judgment of the foreign court, which has considered that the arbitration clause was not valid or not applicable and has rendered its decision, is the court of the seat obliged to recognize the foreign judgment, the Italian judgment in the West Tankers case? The answer, I think, is yes, because pursuant to the Brussels I regulation, there is no control to be exercised on the jurisdiction of the foreign courts. And therefore, the judgment has to be recognized, and it's the award, even if it has been rendered prior to the foreign judgment, which will be sacrificed. And it seems to me that the same applies under the Lugano Convention. Precisely in order to avoid the conflict which the West Tankers judgment makes possible. A revision of the regulation, Brussels I regulation, is now under consideration. There is a proposal by the Commission to give priority jurisdiction not to the court seized, not to the arbitral tribunal, but to the court of the seat of arbitration, in case it's different from the court seized of the merits of the dispute, which would have to stay the proceedings and wait until the court of the seat decides whether the arbitration agreement is valid and applicable, and then the decision of that court will be recognized in all the member states of the European Union. In fact, there has been a lot of criticism against this proposal, and it seems that the Commission has given up this idea. The criticism comes essentially from the authors, and not only but mainly maybe French authors, which are in favor of the negative effect of competence, because of course that's exactly the opposite of the priority of the arbitral tribunal to decide on its own jurisdiction. I come to the third and last issue, conflicts between two awards. Can there be conflicts between two awards? Here again, I will distinguish between purely intellectual conflicts and material conflicts. Purely intellectual conflicts are generally caused by the fact that it has not been possible to bring all the closely related claims before a single arbitral tribunal. There are two procedures before two different arbitral tribunals, but the issues are at least partially the same before both tribunals, and they can have different views on the same facts. So there will be intellectually conflicting awards. There can also be intellectually conflicting awards rendered by a single arbitral tribunal in one single procedure. That will or may happen if the tribunal has decided to bifurcate the proceedings. For instance, and that's often the case, because it wants to decide first on the principle of liability, and then only, if there is liability, in a second phase on the quantum. And after rendering a first award, deciding that there is liability, the tribunal realizes that it made a mistake in the finding of facts, and that would have an impact on the quantum, and would like to correct the mistake. But it's impossible. As Claude Raymond, in a famous award, he was the chairman, has explained, the arbitral tribunal has the duty not to contradict itself. Of course, it's a very awkward situation, and that's an argument for many practitioners of arbitration to be against bifurcation, but still bifurcation has its merits. But it's risky. All that I have been just saying is not specific to international commercial arbitration. I come to material conflicts which are specific, and which are both material conflicts and international conflicts. Internationally material conflicts. For a material conflict to exist, the awards must concern the same parties, and the claims must be either identical or mutually exclusive. Normally that should not happen. because the tribunal which is seized by the second request should refuse to adjudicate the dispute. And the legal basis for this refusal would, in my opinion, but there are other opinions, be the lack of jurisdiction. Because the arbitration agreement is strong enough to give jurisdiction over a given dispute to one tribunal, but not to two tribunals. So after one tribunal has been constituted, the effect of the arbitration agreement regarding the dispute is exhausted. It cannot be relied upon a second time for the same dispute. And for that reason, if the second arbitral tribunal nevertheless accepted to adjudicate the dispute, its award should be, or could be, set aside for lack of jurisdiction, even if it was rendered before the first tribunal had rendered its own award. And therefore, any conflict between two awards would be resolved. There is, however, one situation in which it is normal that a second award be rendered, and that is when the first award has been set aside by a court of the seat of the arbitral tribunal. The claimant starts again, and so there's a second procedure and a second award. Within the legal order of the seat, there is no conflict, only the second award exists. And normally, there should be no international conflict either, because only the second award should be recognized in other countries. And that's provided in Article 5.1e of the New York Convention. The recognition of an award may be refused if the award has been set aside in its country of origin. And that is the rule in most countries. But it's not the rule in France. In a series of famous decisions, Norsolor, Hilmarton, Poutrabali, the French Cour de Cassation decided that the fact that an award had been set aside in its country of origin was not a bar to its being recognized in France. I take the Poutrabali case, the most recent one, and the most striking one, I would say, as an example. Poutrabali was an Indonesian company and had sold a quantity of white pepper to the French company Rina. The pepper was lost in a shipwreck, and Rina refused to pay the price. There was an arbitration clause, arbitration in London, under the auspices of the International General Produce Association. The arbitral tribunal, sitting in London, decided that Rina was not under an obligation to pay the price. However, under the English Arbitration Act, a party can criticize the way English law, which was applicable, was construed by an arbitral tribunal by seizing the High Court of Justice. And Poutrabali did that. And the High Court decided that English law had been wrongly construed. In consequence, a second award was rendered, applying correctly English law and deciding that Rina had to pay. And that second award was substituted to the first one. Nevertheless, Rina sought the exequatur in France of the first award and obtained exequatur, leave to enforce. The appeal from that exequatur order was dismissed, and the appeal from the decision of the Court of Appeal was also dismissed by the Cour de Cassation on the 29th of June 2007. In the meantime, Poutrabali had obtained exequatur of the second award, and it was a complete mess, of course, because both awards were recognized, but very quickly the Court of Appeal decided that the second award could not be recognized, and the order was quashed, because there was already an award having received exequatur in France, and there was a contradiction between the two. Still, the result is somewhat surprising. The second award that had, according to English judges, England being the country of the seat, correctly applied English law, which was the law chosen by the parties, was denied enforcement, although it was also perfectly regular, considering the criterions for a control under French law. But since it was too late, the first award had already been recognized, then it's only the first award that was recognized, although that award had wrongly construed English law and was declared unenforceable in England and everywhere else in the world. The French solution is based on the theory of delocalization, and that's described in the decision of the Cour de Cassation. I quote, "An international award which is not integrated within the legal system of any state is a decision of international justice, which must be reviewed pursuant to the rules in force in the country where recognition or enforcement is sought." It's the idea of delocalization, or even maybe, the formula is somewhat ambiguous, the idea of integration not in a state legal order, but in an international legal order, maybe lex mercatoria. Whether or not one finds this doctrinal foundation of the solution convincing, and personally I don't, it is clear that the result practically is disastrous. And on that sad note, I now conclude. It's clear that decisional harmony is not always achieved, and that conflicting decisions do exist. Could the situation be improved? Concerning purely intellectual conflicts, one improvement would consist in adopting a less shy attitude regarding the admissibility of closely related claims in the same arbitral proceedings. As an example, the joinder of a third party is not accepted in ICC arbitration after an arbitrator has been appointed. The result is that a second arbitration has to take place involving the third party, which was not accepted within the first proceedings, and there is a risk of conflict. The Swiss rules are more flexible. Article 4, paragraph 2 of the Swiss rules are much more open to the bringing together of closely related claims. The adoption of flexible rules in case of multi-contract situations is also desirable, and fortunately that's obviously the new trend, and here the new ICC rules are rather open to the possibility of bringing claims based on two different contracts before one arbitral tribunal in the same proceedings, subject to some conditions, though. As to material conflicts, which are more embarrassing than simply intellectual conflicts, their main source is the divergence of views between two states regarding either an arbitration agreement or an arbitral award. And such a divergence cannot be totally eliminated. In various circumstances, a state makes its views legitimately prevail over the views of another state. But what seems to me to be a paradox is that sometimes the aspiration to a universal vision of international arbitration leads in fact to increased actual conflicts. I'm thinking here of the lex mercatoria or the more recent invention of an ordre juridique arbitral, because by advocating the notion that international arbitration is a legal order in itself, or is the judicial system of the Societas Mercatorum, one invites the courts of the country in which the recognition of the award is sought to consider the award in itself. That's what the Cour de Cassation did in the Putrabali case, as a product of the allegedly universal legal order, and therefore to disregard the views of the other states. And that leads to the results that we have seen in the third part of the conference, which I regard as harmful. And my final conclusion would therefore be that the law of international arbitration is not completely separate from private international law, that the main objectives of private international law are relevant in the field of international commercial arbitration, and that among them, decisional harmony should not be forgotten. Thank you.